Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. Greetings, friends. Today we are discussing a topic that is important for every individual who wants to protect their life's earnings, property, and legacy in a safe and dispute-free manner for future generations. You may have also wondered, should I make a will or should I create a trust? Let us explore the differences, the legal aspects, and which option is more suitable for your situation. 1. What is the difference between a will and a trust? Both wills and trusts are legal instruments through which you can plan the distribution and management of your assets. A will is a legal document that takes effect after your death, where you appoint heirs for your assets. It falls under the Indian Succession Act, 1925. On the other hand, a trust is a structure you can create even during your lifetime. You, the settlor, transfer your property to a trustee, who manages it for the benefit of one or more beneficiaries. Trusts are governed by the Indian Trusts Act, 1882. While a will can become a public document, a trust arrangement remains private and confidential. 2. What is a will? A will is a document where an individual, known as the testator, states how their property should be distributed after their death. The will can specify who gets what share, who will act as guardian for minor children, and any other wishes regarding the property. As per Section 63 of the Indian Succession Act, a will must be signed in the presence of at least 2 witnesses and must be free from coercion, fraud, or undue influence. If there is no will, property is distributed under the laws of inheritance, which can often lead to family disputes and lengthy court battles. 3. What is a trust? A trust is a legal arrangement where a person known as the settlor transfers property to a trustee, who manages it for the benefit of one or more beneficiaries. There are 2 major types of trusts. 1. Revocable trust can be altered or revoked by the settlor during their lifetime. 2. Irrevocable trust, once created, it cannot be modified. Trusts may also be private trusts for family or personal purposes, public trusts for charitable, religious, or social causes. The main purpose of creating a trust is to allow structured, conditional, and private distribution of property. 4. When should you make a will, and when should you create a trust? If your property is limited, your family is trustworthy, and you wish to avoid complications or heavy expenses, a will may be the simpler and more cost-effective solution. It is easy to create, legally recognized. However, if you own multiple properties, have a complex family situation, or wish for property to be distributed in phases, for example, when the child turns 25 or completes higher education, then a trust would be more suitable. A trust is especially useful when there are special needs dependents, or when you want to maintain control over how and when assets are used. For instance, you may specify in a trust that funds can only be used for education, health, or marriage. If you also want to donate a portion of your wealth to charity or religious causes while maintaining control, a trust is the best legal tool for such purposes. 5. Case study: how a trust prevented disputes. In one high-profile business family, the patriarch created a trust that divided his wealth into 3 parts, 2 for his children and 1 for charity. He defined specific conditions under which each beneficiary would receive their share, such as completing their education, staying sober, or participating in family business. After his passing, the trustee followed the instructions and distributed the assets accordingly. There was no probate required, no court case, and the entire transition was smooth and dispute-free. 6. Disadvantages of a trust. Although a trust has many benefits, there are also a few downsides. Creating a trust involves higher initial costs, such as legal drafting, registration, and consultation fees. It is also essential to choose an honest and capable trustee, because if the trustee is untrustworthy, they may misuse the property. Maintaining a trust also requires periodic review and active management. 7. Final advice and comparison. The bottom line is that both a will and a trust are useful, but their suitability depends entirely on your circumstances. If you have limited assets and your family structure is simple, a well-drafted will is sufficient. But if you want to distribute assets privately, gradually, or under specific conditions, or if there is a possibility of dispute, then a trust provides better protection. Always consider your assets, your beneficiaries' needs, and your long-term vision while choosing between the two. And if in doubt, consult an experienced legal advisor to guide you. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.